Aretha Franklin's sons are in court this week battling over the control of her estate and assets. The trial centers on two wills that were handwritten by the Queen of Soul and that were found months after her deaths. Jurors are tasked with determining whether a 2014 document found under sofa cushions in Franklin's home can be accepted as a valid will. Two of her sons believe that it should be, but another son is defending the validity of a 2010 handwritten will found inside of a locked cabinet. Both documents were discovered in 2019, a year after her death. Reid Weisbord joins us now. He's a distinguished professor of law at Rutgers University. Reid, Aretha Franklin died 5 years ago. Let's begin with, why is this trial happening just now?
So a normal estate can take upwards of a year or more to wind its way through the probate process. That includes providing notice to interested parties, settling creditor claims, paying taxes, selling real estate that might have to be disposed of, and divvying up the estate among the beneficiaries. If you're putting on top of that a contest or litigation or a dispute among the beneficiaries, that adds to the dimension discovery, the necessity of taking depositions, acquiring evidence from both sides, and potentially also obtaining expert witnesses, in this case, probably handwriting experts, to determine the authenticity of the handwritten will.
Here's what I don't understand. I was just reading, of course, there's a 2014 will, there's a 2010 will. I mean, if we can call them will. The 2014 would obviously seem like the one that is valid, given that it's closer to her time of death. Why is that in question?
So my understanding is that both are handwritten wills. Some states allow a handwritten will that doesn't contain witness signatures to be valid if it is in the testator, the person who made the will's handwriting, and it is signed by the testator, and it's intended to be a will. And so there are two issues here that I see. One is, do we have a valid signature? My understanding is the 2010 document was signed on every page, notarized, whereas the 2014 document had a smiley face, and she also wrote her last name, Franklin. Is that latter 2014 smiley face plus Franklin signature? And did Ms. Franklin actually intend for either of these documents to be a will? If it wasn't actually intended to be the piece of paper that Aretha wanted to be as probated as her will, then it doesn't count.
I mean, so I get it. One is notarized, the other, but they're both, the other isn't, but they're both hidden or somewhat hidden in her house. Do you see a scenario where neither of them are valid? And if so, then what would the will be, and who would get what?
Absolutely. It's certainly possible that neither will is valid. And if both wills are invalid and there's no other will that's brought forward, then the estate would go through a process called intestacy, which is the default estate plan. And Ms. Franklin was not survived by a spouse, so that would mean that her descendants, 4 sons, would each take equally.
I see. Reid Weisbord, thank you so much.
Thank you.